I don't answer questions.
Okay, I don't really know how to respond to that, sir.
You bastard.
Bastard.
You either fight me or you lose your teeth.
You find me up UCTs.
Captain Awesome.
Hey guys, Rogue Nation here with you today. Today we're going to be going over my appeal to the state of Georgia. It's for the Paulding County case where I was convicted last year, loitering near inmates. So this is the brief that we submitted to the Supreme Court of Georgia, as you can see here. And we're going to go over a little bit of it here, just a second. Alright guys, so we can see here is part 1 introduction. I'm going to go ahead and read it. I'll blow it up so you guys can hopefully see it on screen. Oh, I really blew it up. Alright, it says this appeal involves 2 constitutional questions. First is OCGA 42-5-17, which is the loitering near inmates statute. Violate due process as applied to appellant's conduct. Appellant was arrested and prosecuted pursuant to this statute for refusing to leave the publicly accessible parking lot of a residential substance abuse treatment facility, RSAT, after being ordered to leave by a staff member of the facility. At the time, appellant was exercising his First Amendment rights as a journalist to film the facility from the parking lot for later publication. Next, appellant was denied the opportunity to present his defense to the charges brought against him when the trial court denied his request to charge the jury on the lawful exercise of First Amendment rights as a defense to the charges. Appellant asserts that the lawful exercise of his First Amendment rights was an affirmative defense to the charge of loitering near inmates brought in count 1 of the indictment. Appellant also asserts that the First Amendment was a defense to the charge of obstruction of an officer in count 2 of the indictment. An element of that offense requires the officer to be acting in the lawful course of his official duties at the time of the incident. In this case, the officer ordered appellant to leave the parking lot of the RSAT facility because he was filming. If appellant was lawfully exercising his First Amendment rights as a journalist at the time, the officer would not be acting in the lawful course of his official duties, and appellant would not be guilty of a crime. However, the trial court refused to give a jury instruction on this concept of law. Alright guys, so then it goes into like facts of the case and stuff, which if you haven't seen the video, I'll have a link to that below so you guys can check out the video and see what the facts of the case are. Because, I mean, it's on video, you can't get, much better than that. Also, if anybody wants to read this whole brief, just email me and I'll be happy to send it to you. It was filed September 4th, so, and their reply brief, I do believe, is due back on the 24th or the 29th, somewhere around there, so should be getting that back pretty soon. So, okay, so we'll get into here. It says the trial court erred when it denied appellant's due process challenge to 42-5-17. Said statute was too vague to be enforceable as applied to appellant's conduct. And it says here that 42-5-17 fails to meet the requirements of due process in several particulars. First, the statute is silent as to any guidelines informing a warden when they are authorized to issue an order to desist. Unlike private property owners, government officials cannot arbitrarily bar someone from public property. There are areas of government-owned or controlled property that are not accessible to the general public. Moreover, there are various reasons for limiting or prohibiting access to government-owned property, security, preservation, etc. However, when the government allows public access to property, they cannot arbitrarily or discriminatorily take that access away. A government official cannot do on an ad hoc basis what a written statute could not. This case is a prime example of why guidelines need to be in place. Detention center personnel approached appellant while he was filming from the parking lot outside the perimeter fence. He was present during the daytime and was not attempting to conceal himself or his activities. He did not attempt to make entry to the facility, not even when the gate was electronically unlocked. Moreover, he did not attempt to damage or interfere with the operation of the perimeter fence or gate. He merely filmed signs that were posted on the fence. The defendant was not causing a disturbance. He was not being disorderly. He was not preventing or interfering with the operation of the facility in any way. However, he was asked to leave. Why? Because he was peacefully engaging in lawful activities protected by the First Amendment. Even after he identified himself as a journalist, he was labeled a suspicious person for engaging in this lawful conduct. Moreover, the staff continued their efforts to get him to leave after they knew he had a legitimate reason for his presence. Unlike other similar laws, this statute provides unfettered discretion for a warden to arbitrarily bar persons at whim. As applied to the defendant's conduct, the lack of guidance in the statute resulted in the defendant being arbitrarily asked to leave in retaliation for peacefully exercising his First Amendment rights as a journalist. Therefore, the officers who arrested him were allowed to photographically document the scene of this heinous crime. They photographed many of the same areas the defendant documented with his video camera. Moreover, they were in the same parking lot when they did so. However, they were not told that they could not photograph these areas, and they were not asked to leave. It is unknown whether a major corporate news outlet would have been treated this way, but the facts of this case show that the statute was applied in an arbitrary and discriminatory fashion. The lack of standards for enforcement of the statute by authorities violates due process. See City of Chicago v. Morales. Term no apparent purpose gave insufficient guidance to police officers in determining when to issue an order to disperse under Chicago's loitering law. The term where inmates are kept also provides both 1. Insufficient guidance for officers enforcing the law, and 2. Insufficient notice to citizens to satisfy the requirements of due process. Unlike other trespass-type laws, where inmates are kept, does not define a specific boundary from within which a person must remove themselves to comply with the statute. This lack of a specific boundary led to 2 different opinions as to where the defendant was lawfully allowed to be. The detention center staff believed that appellant was required to remove himself from the property entirely. When confronted by detention center staff, he was told that he had to exit the property. However, appellant believed that he was legally on the property if he was in an area accessible to the general public and did not go inside the perimeter fence. This is a reasonable conclusion given the circumstances. The only barrier to entry on the property is the perimeter fence. Moreover, the Department of Corrections chose to label it as the perimeter fence. The perimeter of an object is commonly understood to be its edge or boundary. Since kept or keep is commonly understood to mean to maintain possession or control of something, a person of ordinary intelligence could reasonably conclude that where inmates are kept would extend inside and up to the perimeter fence around the facility. This is where access and egress to the facility is controlled by a gate. The prisoners are kept, possessed and controlled, in the building and yard inside the fence. This is a reasonable interpretation of the statute, but it was interpreted differently by both the detention center staff and the arresting officer, thus illustrating the vagueness of the statute's prescriptions. Where inmates are kept suffers from the same constitutional deficiencies as the term area did in Chicago v. Morales, and the term locality did in Connolly v. General Construction Company. In Chicago v. Morales, a plurality of the court found in Division 4 of the opinion that the term disperse and remove themselves from the area was unconstitutionally vague because it did not instruct citizens on how far they had to go to comply with an order to disperse. In Connolly, a majority of the court found that the term locality used to calculate the wages to be paid for labor in an area did not provide sufficient guidance. They opined that no one could say with any degree of accuracy what constituted the locality from which a current wage was to be calculated. Moreover, the justices opined that the state Supreme Court's interpretation of that term to mean place, near the place, vicinity, or neighborhood did not remove the uncertainty. Specifically, the justices reasoned that neighborhood was as susceptible to variation as the term locality. Both terms are elastic and, depending upon circumstances, may be equally satisfied by areas measured by rods or by miles. From these two opinions, it is clear that legislators must use well-defined boundaries when defining an area of inclusion or exclusion in a statute. Turning back to the statute at issue, where inmates are kept does not clearly define the boundaries within which the warden may lawfully give an order to desist, or from which a citizen must remove themselves to comply with such an order. One person might understand it to include inside and up to the perimeter fence surrounding the facility. Another person might put significance on the guard line outside the perimeter fence. A third person could believe it to mean the property line on which the facility is located. To others, it could even mean an area extending somewhere beyond the property line. When people are asked where they are from, they will commonly refer to the city or state in which they live. When a person is asked where they got a particular item of clothing, they will commonly refer to the store at which it was purchased. Where is a term relating to location. It describes a place. It does not define the boundaries surrounding that place. For instance, when asked where they are from, people may tell others that they are from Dallas, Georgia, even though they reside outside the city limits. As it does not sufficiently define the boundaries from which a citizen may be excluded, where inmates are kept is unconstitutionally vague and violates due process. The statute also fails to provide due notice to citizens concerning what they must do to comply with an order to desist. The statute provides that once a person is given an order to desist, they may not loaf, linger, or stand around. These are slang terms used to describe activities done without a particular purpose or plan. To loaf is commonly understood to mean to move slowly and without a particular purpose. To linger is commonly understood to mean to remain somewhere longer than is necessary to complete a task, or to be slow in departing after the task has been accomplished. To stand around is commonly understood to be idle without doing anything constructive. These slang terms are imprecise and subject to much interpretation. For instance, if to loaf is to move slowly and without purpose, would someone comply with the statute if they ran or had a lawful purpose for walking slowly, e.g. moving slowly to stabilize their camera? Although desist means to stop as opposed to leave, would a person still be in violation of this law for lingering if they departed slowly? How quickly does someone have to depart in order to not linger? Are they lingering if they have not completed the task they came there to do? How fast does someone have to move to not be considered loafing or lingering? Are they considered to be standing around if they are engaged in an activity such as the defendant was when he filmed the facility while standing in the parking lot? Under the terms of the statute, a person could be arrested for violating this law if the officers enforcing it arbitrarily believed that they were not moving fast enough. Unlike the terms remain upon the land or premises of another, fail to remove himself or herself from the premises, and fail to leave, used in other similar statutes, the terms loaf, linger, and stand around do not clearly define what a citizen must do to comply with an order to desist, given pursuant to OCGA 42.517. Therefore, it does not meet the notice requirements of due process. Loaf, linger, or stand around also leaves complete discretion to law enforcement to determine when to arrest someone for purportedly violating the statute. All of these terms require a lack of purpose on the part of the person allegedly violating the statute. However, as this case is the prime example, even a constitutionally protected purpose may not be enough for some officers. Here, appellant was engaging in First Amendment protected activities. However, he was told to leave. Moreover, although he had not completed his task of filming the facility at the time, he was arrested nonetheless. The lack of guidance for law enforcement in this statute tends to encourage arbitrary enforcement. Therefore, it does not meet the requirements of due process. And we're going to wrap that up there, guys. And if you want to read more, just email me. I'll send you the whole thing. There's still 6 more pages left at the end here, and I did skip a whole bunch in the middle. Again, a lot of that was just clarifying the jurisdiction and the process and stuff, the eras that were, put together. So, yeah, if you guys want to read that stuff, just hit me up on email, patriotdiscussions@gmail.com, and I will send that out to you guys so you can take a look at that. I will notify you guys again probably in a week when we get the brief from the state and see how they answer these issues, and we'll go over that then as well. All right, guys. So, appeal to the Georgia State Supreme Court. Wouldn't it be awesome to get some case law in the Georgia Supreme Court? That would be awesome. So, all right, guys. We'll talk to you soon. Thanks for watching.